New York has actually had a weekly pay requirement for certain employees since 1890, over a century ago. And this started with the Weekly Pay Act, as it was called. It was enacted to combat employers failing to pay their employees after a job was completed. And it was geared towards protecting per diem employees, so employees who were doing jobs at times. It required certain employers, such as manufacturing and mining companies, to pay weekly to each of its employees the wages earned by such employees within 6 days of the date of such payment. And that was the language that was included in the Weekly Pay Act in 1890. It was designed to compel prompt payment to small wage earners. So that was also language that was in the law in 1890, a small wage earner. The Attorney General, through factory inspectors, as they were called at the time, enforced the statute. So although the statute by its terms applied to all employees, the courts quickly added gloss to this by stating that it was only applied to laborers and working men, really looking at low-income manual workers. And again, it was the Attorney General that enforced this statute. There was no private right of action. Employees couldn't bring forward claims on their own behalf. It was the Attorney General who looked for violations and ended up giving a fine to an employer who failed to timely pay their small wage earners. As discussed in a recent New York Law Journal article, the AG interpreted this clause within 6 days of the date of such payment to mean that paying employees biweekly was permissible, because that language was interpreted as meaning 6 days after the end of the work week. So biweekly in how those payments were made was permissible. A similar clause is found in the current version of the law, which states that a manual worker shall not be paid, quote, later than 7 calendar days after the end of the week in which the wages are earned. Very similar language. We see 6 days versus 7 days, but the idea still is that it's after that work week. And although there have been various changes to this law, the text is substantially the same as it is now. This is all related to this legislative history of Section 191 specifically.